procurement system of the Ministry of Commerce.
Yes, Mr. Speaker, sir, what MMI proposed, MMG, right, was a very good deal for the country. Because with this, we have managed to save more than...
Allow the Minister, please. Decorum, allow the Minister. Allow her to finish with her reply.
We have managed to save more than 700 million rupees with this contract. And, time was of essence. It was a good deal, so we took the deal. Because I gave you a list of, benefits that we were getting from this company.
I mentioned to the Minister the possibility in her own e-procurement system of a reverse auction where people can drop the price as much as possible, which would have allowed the other 7 to drop their prices if they wish to.
In fact, Mr. Speaker, sir, was the only companies who... In fact, Mr. Speaker, sir, MMG was the only companies which accepted to be paid in 2 Mauritian rupees. That's why we go for it. And I've given all the, the benefits that the country is going to derive from this contract.
Mr. Speaker, the question of the contract being made public is extremely important. As she will know, the tender document, the original tender document of May, is a public document. The bids that the tenderers make are also public and published by the Ministry on the e-procurement system. Why is the famous deal with the MMG kept secret? Are we not to know what are the product specifications? Are we not to know at what rate of conversion the rupee, the dollar is going to be converted so that MMG are paid? Are we not to know all the details about this, the credit terms? You say it's 2 months. This is what you say. But unfortunately, Mr. Speaker, this House has seen Molnupiravir, has seen packet blister, has seen the problems with the STC, and we do not trust.
Stick to your question. Reply, Minister.
Mr. Speaker, sir, no other suppliers provide us such facilities for payment. We got 2 months credit. And also, we got to pay into Mauritian rupees, allowing us to save also 250 million interest, but otherwise should have gone to pay to the banks. So it was a very good deal. And then maybe for you it's peanuts. Maybe for you it's peanuts, because we've seen that in 2 coffers there were 220 million kept at home. Maybe it's peanut for you. But for the population, it's for the population.
Order.
Mr. Speaker, I
haven't completed. I haven't finished my reply. And every saving is important after this period of COVID. Every saving, even 1 cent, is good for the country. So we had to accept this deal. It was a very good deal for the country.
Minister who doesn't know about the cost of the contract, who doesn't understand what is the price equalization account, who doesn't know anything about reverse auction, I found her attitude surprising. I'd like to ask the minister. She doesn't know yet. She is
Put your
anyway.
question. Don't make insinuation. Put question.
You allowed her to make
Time is
insinuation.
already over.
Time is over because she took 22 minutes, Mr. Speaker. That's why time is over.
Continue.
Mr. Speaker, I'd like to ask Honourable Minister. I had my doubts about this NMG. Now that she's refusing to publish the information, to publish a contract, I and many people in Mauritius will be compelled to believe that there is anguille sous roche in that contract, and that is why she is not publishing it.
Mr. Speaker, sir, I have not refused to publish the contract. I've said that there is a confidentiality clause, right? And we need to get the agreement of both parties. And the Honourable Leader of the Opposition, as an accountant, he knows nicely the confidentiality clause in any contract. Thank you, Mr. Speaker, sir.
Last question. Put your last question.
Yes, Mr. Speaker. This is the question I'm going to ask her. If you consider the price of petrol in Mauritius, it's at $1.6 per litre. I'm talking about Mogas. And this is approximately the same amount that the UK consumer or the European consumer will pay for their litre of petrol. Yet the salaries of these persons are about five times the price, the salary of the Mauritian.
Leader of the opposition, I am on my feet. Respect decorum in this house. I am on my feet. You have no right.
Stop shouting. What am I doing wrong?
I should give you permission to continue with your question only. Yes. No comments. Question.
What am I doing wrong? Are you asking her whether she's aware?
Put your question, no comments. Last question. Time is going.
I will put my question again. Last question. Given that the price of petrol here, the retail price of Mogas, is equivalent to $1.6 per litre, this compares about the same to what a European, USA it's even cheaper, European or English consumer is paying. And does she know that these consumers earn about 5 times more on average than the Mauritian? Will she agree?
Leader of the opposition, I don't allow this question. This is demagogy. This is demagogy. This is not factual. This is demagogy from your part. I don't allow this question. If you want to reply to the first part, it's okay. The second part is demagogy.
Yes. You know, I want to reply, Mr. Speaker, sir.
The first part you may go.
Yes, the first, yes. You know, Honourable Mr. Speaker, Honourable Leader of the Opposition, we have to compare like with like. This is what I teach to my students in accounting. We have to compare like with like. And you're comparing us with, you know, UE comes from highest, you know, with highest pay and all. Why don't you compare us with Seychelles, our neighbor just close by, and see how much they are paying?
Order.
You see?
Order. Decorum. Decorum. Order. Parliamentary democracy. Carry on, yes. Honourable Minister.
So we have to compare like we like, Mr. Speaker, sir. Okay, and we cannot compare ourselves with countries who are producers. Thank you.
Time over. Honourable members, the table has been advised that PQB 1256 will be replied by the Honourable Prime Minister, time permitting. Prime Minister's question time. Honourable Tim.
B 1240.
Mr. Speaker, sir, this question relates to issues falling under the purview of the Security Division of the Prime Minister's Office, which deals with national security. It would not therefore be appropriate for me to disclose information pertaining thereto. Mr. Speaker, sir, I wish to emphasize that it has always been the practice in this House not to disclose such information, and successive governments have since independence adhered to this principle scrupulously. However, I wish to reassure the House and the honourable member that all the procurement exercises in question and the disbursements in relation thereto have been carried out in full compliance with the applicable laws, rules and regulations.
May I know from the Honourable Prime Minister, if everything has been done, as he said, in accordance with the law, why is it that the Financial Integration Unit has applied for a restriction order to freeze the bank account of DNS International Limited because they represent proceeds of a crime? All these monies paid with the government there was an application to freeze those monies.
Well, Mr. Speaker, sir, this is not in relation to this question. This is, the honourable member is talking about a case which is actually pending before the court. And he wants me to comment on a case which is actually pending before the court. I think he is a lawyer, he should know better than anybody else. Now, I don't want to go into the detail, but is the honourable member saying that the restraining order concerns only this, any payment that has been made? I think he knows the case quite well, and he should know better that you have to not to try to mislead the population with regard to what is being before the court and with regard to this question.
The judgment is in the public domain. In the judgment, the learned judge of the Supreme Court set out extensively all the contracts, the terms of contracts awarded by the Security Division to the DNS International for the purchase of equipment from Verint System Limited, an Israeli company which, according to its website, specializes in interception of vocal messages. So may I know from the Honourable Prime Minister, being given that, according to the judgment, above $15 million, more than 650 million rupees has been paid to Verint for these voice intercepting messages, whether these equipment have been used, and if they have been used, whether a judge's order has been obtained before making use of these equipment.
Mr. Speaker, sir, let me remind this honourable member, maybe he's not aware, I think, and it's good that I remind him of the past practices. And I say since a very long time ago. Let me refer him to a question that was put at the sitting of the 22nd of June 1971 at the committee stage by Honourable Olivry at that time. The question was about increased provision of the special branch. And the minister who replied, Honourable Yusuf Mohammed, I quote, "The information my honourable friend is searching for is secret because it happens to be the secret police. C'est la police secrète." I refer him now to a sitting of the 21st of July 1992, a question put by Dr. Honourable Bulel to Sir Anirudh Jagnnath, Prime Minister, who replied, "At any rate, sir, the NIU being responsible for state security, it would be neither appropriate nor proper in the interest of security to debate any question relating to it in this August Assembly. This is a convention which has existed since independence concerning our intelligence service, and any government should observe it scrupulously. The sitting of the 15th of July 1997, a question put by Honorable Hervé Duval and being replied by Honorable Rajkeshwar Paryak, then Deputy Prime Minister. And I only quote what is relevant because the Honorable member was asking about National Intelligence Unit and so on. It would not be in the interest of security to disclose the breakdown of the expenditure incurred. A question that was put by Honorable Jiwa during the Appropriation Bill 1997-1998, question was about providing details with regard to the amount to be voted for, again, for security issues. And Dr. Navin Ramgoolam, Prime Minister, replied that he did not give any detail concerning the sum to be spent for each project or for the different items. Sitting of 24th of June 2003 at committee stage, Dr. Honorable Boulel asked a question about running costs of the security unit. Honorable Paul Béranger, acting Prime Minister, replied, "This is a case where I am sure the former Prime Minister will agree with me. In matters of security, we have to be very discreet, so I won't go into a lot of details." A sitting of 7th of December 2010, committee stage, again, question put by Honorable Lejongar about acquisition of CCTV street surveillance system for Grand Bay and Port Louis. Acquisition of CCTV system, Mr. Speaker, sir. Dr. Navin Ramgoolam replied, "I can't give details about security matters, but it will be manned properly." Again, at the sitting of the 21st November 2011 at committee stage, I put a question at that time about counter-terrorism unit, about security unit, and Dr. Navin Ramgoolam replied that where are they based? In fact, we need to find a different location. Now, they are meeting in places which have to be kept obviously secret, but we think we need at least have a place where nobody will know these people work in that unit. And another, at the sitting of the 25th of June 2018, question put by Dr. Honorable Boulel, National Security Services. Again, the Prime Minister replied, the information pertaining to national security is by nature classified. It cannot be divulged. And at the sitting of the 24th of June 2019, Honorable Bhagwan had asked a question about national security. The Prime Minister replied, we all know with regard to the national security services, we normally do not provide information. So, Mr. Speaker, sir, it has been a tradition throughout by all governments, not to answer or give details with regard to security matters or matters which have to be kept secret in the public interest.
So, you still have a question?
Yes, I'm not asking the Honourable Prime Minister to divulge any national security interest details, but being given that we also have a right, a constitutional right to privacy. May I know if the Honourable Prime Minister is prepared to give the assurance to this House that these equipment that has been bought for national security purposes will not be used to spy on political opponents without a judge's order.
Mr. Speaker, sir, let me reply. I think the honorable member is getting confused, really confused, because he has put a question to ask about aggregate value, about procurement method, and about equipment purchase. Now he's coming to another issue completely, whether there is phone tapping, listening, and so on. I think he's lost.
So the question has been sufficiently canvassed. We move to the next question.
B 1241.
Mr. Speaker, sir, I wish to thank the honourable member for this parliamentary question, as it is one of national interest, and it gives me the opportunity to inform the House and the population at large of the rationale behind this measure and the need for all users of mobile phones, including the business community, tourists, visitors, and the population, to ensure compliance with the Information and Communication Technologies Registration of SIM Regulations 2023. Mr. Speaker, sir, the House would recall that in the report of the Commission of Inquiry on Drug Trafficking, chaired by the former judge of the Supreme Court, Mr. Pol Lam Shang Ling, and published in July 2018, observations were made at paragraphs 3.26 and 3.28 relating to the misuse of subscriber identity module cards, which are as follows, and I quote, paragraph 3.26, entitled Black Phones. The Commission also heard the use of black phone by persons whose real identity could not be traced out, and the SIM cards belonged to foreigners who had either left the country or the registered owner had passed away, and yet the SIM cards were still active and in circulation, and there was no change in their ownership. End of quote. And I refer again the House to another paragraph, 3.28, ICTA, need to think out of the box. I quote, the Commission was appalled to hear of the sale of 200 SIM cards at one go to an employee of a travel agency who had more than 25,000 SIM cards registered in his name, and who confessed that he was oblivious of the danger and shocked with disbelief when he was informed that some of the SIM cards registered in his name were seized in prisons. The Commission also has evidence that some of the SIM cards registered in the name of foreigners, mainly from Bangladesh, who had left the country, were used in prisons to communicate with accomplices outside and with barristers. The authorities concerned must have proper monitoring of satellite phones as information gathered from the ADSU traffickers are using them. End of quote. Furthermore, at paragraph 11.8 of the report, the following recommendations were made to address the issue of misuse of SIM cards, and which I quote, in view of the heavy dependence of the drug traffickers in the prisons on smartphones, the Commission is of the view that the relevant authority, together with the telephony service providers, must review the sale of SIM cards, especially to tourists and foreign workers. Regulation must be made so that any person wishing to obtain a SIM card must personally fill in the application form with all relevant information to identify and locate the person, and only one SIM card can be given per application to prevent corrupt seller of SIM cards in tobacco outlet to insert more SIM card numbers without the knowledge of the applicant. SIM cards issued to foreign visitors must have a period equivalent to their stay, and thereafter automatically deactivated by the telephony service providers. The Commission has also noted the ease with which the drug traffickers could obtain credit to enable them to use their smartphones. Topping up of SIM cards by using scratch cards must be forbidden. It is for the authorities to find other means to enable their clients to be able to continue using their telephones. With the postpaid system, there will be greater control as the telephony service providers will have to send their invoice at a particular address, and if the amount is not settled within the specified period, the service provider will be entitled to cancel the use of that number which it is actually doing. The Commission heard of the traffickers now resorting to satellite phones. The relevant authority must supervise and control that type of phone, unquote. Following the report, my office, together with the Information and Communication Technologies Authority, held a series of consultations with the various stakeholders concerned, including, among others, the Attorney General's Office, the Police Department, the Ministry of Information Technology, Communication and Innovation, the Ministry of Foreign Affairs, Regional Integration and International Trade, the Passport and Immigration Office, the Bank of Mauritius, the Data Protection Office, as well as the free mobile operators in Mauritius, to explore the possible measures to be taken to address the issues relating to the misuse of SIM cards, thus such as the purchase of SIM cards through impersonation, usage of these cards to carry illegal activities such as criminal intimidation, extortion, unsolicited calls, and drug trafficking. Mr. Speaker, sir, the ICTA also took into consideration the best practices which have been implemented in other countries. For example, India has implemented strict regulations and procedures for SIM card activation, including mandatory biometric identification. It is also noted that Germany has mandatory identity requirements. Registration requirement in Australia is also to enhance security and track potential fraud. Hence, on the basis of international best practices, the ICTA developed a legal framework to address the issue of misuse of SIM cards, and following which it held discussions with government institutions, regulatory authorities, enforcement agencies, and the mobile telephony operators. These deliberations resulted in the preparation of the Information and Communication Technologies Registration of SIM Regulations 2021, which also took into consideration some of the views submitted by the telephony operators. The said regulations were thus promulgated on 31st December 2021, with effective date of operation on 1st April 2022, to provide the free local operators, namely Mauritius Telecom, MTEL, and MTML, a 3-month period to set up the required infrastructure and database for the implementation of the regulations. Hence, the current holders of SIM cards would have registered their SIM cards not later than 6 months, that is by September 2022, after the coming into operation of the regulations, failing which their cards would have been deactivated. Mr. Speaker, sir, following the promulgation of the regulations in December 2021, the ICTA had several technical meetings with the operators and other concerned stakeholders for the smooth implementation of the project. However, during these discussions, several technical problems were identified. These problems related to the setting up of a middleware system at the ICTA and the upgrading of the respective IT infrastructure of the operators. Consequently, the ICTA informed my office that due to these advanced upgrading works required to the existing systems of certain stakeholders, including the operators, additional time would be required by them for the efficient implementation of the regulations. In light of the technical problems encountered by the operators, government agreed to postpone the coming into operation of the regulations from 1st April 2022 to 31st October 2023, and the deadline for the registration of all active SIM cards from September 2022 to 30th April 2024. Mr. Speaker, sir, the Information and Communication Technologies Registration of SIM Regulations 2023, which takes into account in a comprehensive manner all the recommendations pertaining to the misuse of SIM cards in the report of the Commission of Inquiry on Drug Trafficking, provide for a technology-driven mechanism for the registration of SIM cards with focus on traceability on the SIM card owners and mitigation of risks of malpractices. These regulations provide, among others, that all SIM card holders must register their SIM card in person or online by providing, amongst others, mandatory documents such as the national identity card or passport details and recent utility bills to verify proof of address. Service providers will also be required to take the colored photograph of the applicant for the online real-time verification of the subscriber's identity. Clearly defined processes for registration of SIM card for different categories such as tourists, non-citizens residing in Mauritius, corporate entities, public institutions, and diplomatic missions. A public body, corporate body, company, diplomatic mission, or any other organization these entities can change the subscriber in case an employee leaves the organization or in case of death of the employee. There will be a distinct numbering plan for SIM card to be used by tourists and machine-to-machine SIM cards. A new numbering plan would be applicable for tourists to demarcate their SIMs from that of citizens. Only holders of a tourist enterprise license or tourist accommodation certificate may buy SIM cards on behalf of tourists. The SIM card is activated only when the subscriber proceeds with the registration as per the regulations and after successful online real-time verification. SIM cards issued to tourists will have a period of validity equivalent to their visa, and thereafter will automatically be deactivated by the service providers following their departure from Mauritius or cancellation of visa. In case of death of subscribers, the SIM card will automatically be deactivated within 15 days from which the death is recorded by the relevant authorities. A parent or guardian would have to produce his own national identity card and photograph at the time of registration of SIM card for his child. And a subscriber would be required to report the loss of his SIM card to the police within a period of 48 hours. Mr. Speaker, sir, registration is mandatory upon purchase of a new SIM card. Current SIM card holders also need to re-register as from 31st October 2023. Those who should re-register as from that date are citizens of Mauritius, non-citizens residing in Mauritius, corporate bodies, and government institutions. It is to be noted that for registration and re-registration purposes, appropriate identity documents should be presented as follows. For Mauritian citizens, national ID card, personal details of passport, recent utility bill, or any other proof of address. For non-citizens, personal details of passport, unique identification number, residence permit or occupation permit, recent utility bill, or any other proof of address. For tourists, personal details of passport or any other valid travel document and proof of address in Mauritius. And machine-to-machine SIM, a letter from the organization authorizing a person to act on its behalf, a national ID card or personal details of passport for the person acting on behalf of the organization, recent utility bill of the organization or any other proof of address, and copy of the certificate of incorporation of the organization. I am also informed that with a view to facilitating the process, re-registration of SIM cards would be possible, both remotely, that is, through the internet, on the applications developed by the mobile operators, and at any service operators' outlets, free of charge. Mr. Speaker, sir, with regard to Part A of the question, I wish to inform the Honourable Member that the rationale of coming up with these regulations is to allow traceability, mitigate the risks of malpractices, and reinforce security of the telecommunication sector. Accordingly, both the new registration and re-registration processes would be an important step to allow the operators to authenticate and validate details of their subscribers through 1. Real-time verification of applicant details, and 2. Conducting liveness tests and image check where the applicant is applying for registration and re-registration remotely through the internet. As regard Part B of the question, I am informed that the re-registration of the SIM cards will apply to all SIM cards holders, that is, citizens of Mauritius, non-citizens residing in Mauritius, as well as postpaid and corporate customers. Mr. Speaker, sir, concerning Part C of the question, I am informed that for the efficient implementation of the regulations, it is of paramount importance that a reliable and genuine database of SIM card owners be put in place and maintained. In this respect, a middleware system has been installed by the ICTA at the Government Online Center to act as an interface between the operators on one side and the Passport and Immigration Office and the Civil Status Division on the other side. Through this interface, the operators would be able to verify on a real-time basis the name, the national identity card number, and the date of birth of a citizen with the Civil Status Division. On the other hand, for tourists and non-citizens residing in Mauritius, the operators would have the possibility to check the validity of the visa, the passport number, and the unique identification number with the Passport and Immigration Office. As such, upon the departure from or overstay of tourists in Mauritius, operators will be notified accordingly through the interface, following which they will proceed with the deactivation of the SIM cards on the following day. This will prevent the usage of these SIM cards by other persons after the departure of the tourist or overstay of same, as may be the case presently. Mr. Speaker, sir, as I have already stated, the re-registration of existing SIM cards will start as from 31st October 2023, and users will have a period of 6 months, that is up to 30th April 2024, to complete registration of their SIM cards. Presently, there are 2,339,017 active SIM cards in Mauritius, 56,016 in Rodrigues, and 1,036 in Agaliga. To sensitize all SIM card holders on the new regulations and the need for a timely registration of their SIM cards, failing which their SIM cards will be deactivated, the ICTA has already launched its communication campaign since the 4th of October 2023, which will be ongoing till 30th of April 2024 on print, broadcast, and online media. For this purpose, the services of a public relations agency has been retained to conceptualize and conduct the campaign. This campaign is being conducted in 3 phases. Phase 1, the soft launch, which started on the 4th of October in 2023 through the focus program on the MBC, and will be ongoing for a period of 1 month, whereby the focus will be on the need to inform subscribers to re-register his or her existing SIM cards. ICTA has also issued a communique on the 18th of October 2023, and a frequently asked questions sheet has been posted on its website. Moreover, ICTA has also intervened on private radios. Phase 2, to start as from 15th of January 2024, and will take into account the number of re-registration done during the past month, and the campaign strategy will be adjusted accordingly. And phase 3, the emphasis will be to encourage subscribers who have not done so to re-register before the 30th of April 2024. Mr. Speaker, sir, I take this opportunity to invite all SIM card holders residing in our Republic to start re-registering their SIM cards as from 31st of October 2023, as a positive action towards mitigating the risk of the misuse of SIM cards in illicit activities. I eagerly encourage all concerned citizens to re-register their SIM cards as early as possible in order to avoid last-minute rushes. Thank you.
Mr. Speaker, sir, after this quite detailed and lengthy answer from the Honourable Prime Minister, I would like to state that we of course, all support all efficient actions meant to fight drug trafficking. Yet, may I ask the Prime Minister how this tracing system is meant to work when drug traffickers in Mauritius will simply use foreign SIM cards and use mobile internet applications for communication?
Mr. Speaker, sir, the fact that true it is somebody can use a foreign SIM card, does that mean that we don't take action here? does that mean that we don't follow the recommendations that have been made by the Commission of Inquiry on Drug Trafficking? Does that mean to say that, well, we just pay lip service to, and it is in fact the opposition who have been criticizing us unjustly for trying to make people believe that we are not implementing the recommendations of the Commission of Inquiry on Drugs, when we have been implementing the majority of those recommendations. And this is, I have extensively, purposely given all the details, quoting the relevant parts of the report on the Commission of Inquiry and the recommendations that have been made by the Judge Lam Shangling. And now that we are implementing this recommendation, we are being told, well, there is a possibility that somebody can use a SIM card from outside, from another country, and therefore what should we do? What should we do? May I ask the honourable member, what should we do? We just sit down and relax? But Mr. Speaker, sir, irrespective of what the honourable member is saying, as a government, as a responsible government, and as a government which is meant to fight against drug traffickers, we are taking all the necessary measures in order to see to it that we see to it that we are able to plug whatever loophole there can be. This has been a loophole, I agree, as the report has said, this has been a loophole for quite some time, and we are plugging now this loophole.
The Honourable Prime Minister mentioned indeed this report of a Commission of Inquiry on Drug Trafficking. This report was submitted in July 2018. I understand that there has been some technical issues. Still, may I understand why is it that it took almost more than 5 years to the government to implement such measures, and a few months now up front the coming general elections?
Well, Mr. Speaker, sir, we are not implementing the measures that have been recommended by on the report of the drug trafficking, because the elections are coming. We started the very next day, but there is a process. You must understand, we set up a committee to look into all the recommendations. We had all the ministries concerned, all the stakeholders to be involved with regard to what recommendations. First of all, there are, I must say, there are a few recommendations that cannot be implemented. But I again say most of the recommendations have been implemented. And this has taken some time, yes, because there are a number of technical issues that had to be dealt with. I have mentioned in my answer the number, I have not mentioned the number of meetings, but I mentioned that there have been consultations with the stakeholders, especially with the telephony service providers, and there are a lot of issues that had to be addressed. And we have come now to a stage where now we have amended the law, and the law is being applied. So let us look at the good side, and not criticize and to say that, I think you will agree that we need to act against people who are bent to commit offenses, and particularly serious offenses like drug traffickers.
Thank you, Mr. Speaker, sir. In view of the reply provided to the main question, can the Prime Minister provide assurances with regard to the security of personal data of those 2.4 million subscribers? Thank you.
Yes. Mr. Speaker, sir, I am informed that personal data of subscribers are and will continue to be collected and stored by the mobile telephone operators in conformity with the Data Protection Act. The ICTA does not and will not have access to those personal data. The ICTA will act only as a technical interface between the mobile telephone operators and the databases of the Civil Status Division and the Passport and Immigration Office. I am also informed that the connections of the online verification system between the different stakeholders, namely the Civil Service Division, the PIO, the ICTA, and the mobile operators, will be secured and the information exchange will be encrypted. And it is important that I highlight once more that there will be no database at the ICTA, and therefore there will be no possibility for personal information to be retrieved at that level for any use whatsoever.